This video outlines the Institute of Energy Management's Joint Operating Agreement before and after the initial well. This course is a must for those who are getting involved with drilling wells, entering purchase and sale agreements, and acquisitions and divestitures. The Joint Operating Agreement, JOA, was used traditionally to allow parties owning adjoining leases or undivided interests in the same leases to jointly develop the properties. The JOA not only attempts to govern the operations and activities prior to the drilling of the initial well, but provides guidelines and options for the operations after the initial well is drilled. The course covers in detail the following subjects: the impact of lease terms, farm-outs, marketing, and gas balancing agreements, along with title and unit size issues. For example, the terms of leases to which a JOA is subject are controlling as between lessors and lessees and cannot be modified without the joinder of all parties to the relevant leases. Unless lessors are parties to a JOA, which seldom happens, the JOA will not alter the duties owed to lessors under applicable leases. The course covers important questions regarding farm-outs, such as: does a farm-out involve preferential rights to purchase? Does a farm-out represent a cash or acreage contribution described in Article 8C? Do wellbore and depth limitations contained in farm-out agreements impact the application of the terms of the JOA? It is important to understand the dynamics of unit size changes. For example, sometimes the drilling and spacing unit, which is subject to a JOA, will change in size, and this can change the interest of the parties. The course goes into detailed information regarding gas marketing. For example, unlike the early years of gas production, the gas marketing environment no longer involves a contract with a single pipeline purchaser of all the gas produced at the wellhead, with the pipeline allocating the purchase proceeds to each owner in proportion to their working interest. Along with gas marketing, the course covers the handling and marketing issues under the JOA. For example, before 1948, it was not uncommon for operating agreements to provide for the operator to market all the production, especially the marketing of gas, which in earlier times was considered to have little value. Taking production in kind issues, the operator's right to production. It is important to understand this provision. For example, each edition of the model form provides that in the event any party fails to make the necessary arrangements to take its proportionate share of the production in kind, then the operator has the right, but not the obligation, to purchase such production or sell it to others for the account of the non-taking party. Expressed operations is another important area in which full understanding is vital. For example, there are many expressed obligations set forth in the JOA, such as notice and time limits restrictions on marketing. It is important for the operator to become very familiar with these obligations. Determining break-even price points for oil gives the tools you need to put together a safe value under which you can maintain operations under severe downturns in natural gas prices. One of the main key issues regarding the JOA is the operator's standard of care, which is covered in the course. For example, the operator's basic standard of care to the non-operators under the 1989 model form is set forth in Article 5A, which provides that the operator shall conduct its activities under this agreement as a reasonable, prudent operator in a good and workmanlike manner, with due diligence and dispatch, in accordance with good oil field practice and in compliance with applicable law and regulation. Just as important as what the JOA covers is knowing what it does not cover. Do not assume the unmodified form will work for you. Remember that there are many areas of concern that are not covered within the JOA. It is important to familiarize yourself with the court's decisions when it comes to violations under the JOA. This section of the course is a discussion on case law regarding certain provisions in the Joint Operating Agreement. Note, some of the cases cited may have been amended or new rulings handed down. Since the operator is charged with paying bills and distributing revenue, the COPUS, which is generally attached to the JOA, sets forth accounting procedures which operators and non-operators should also be aware of. Enroll today by going to our website at www.instituteofenergymanagement.com.